When people imagine the medieval world, they often picture muddy streets, towering castles, armoured knights, and rulers who governed by whim. It is easy to assume that laws in that era were crude, superstitious, and arbitrary. Yet quietly beneath the clang of swords and the chanting of monks, a series of legal transformations unfolded that would shape the foundations of the modern world. These were not always dramatic revolutions. Many were incremental adjustments, compromises between kings and nobles, between church and state, between merchants and monarchs. But over centuries, those small changes altered how power was limited, how justice was administered, how commerce expanded, and how ordinary people understood their rights. The medieval period, stretching roughly from the 5th to the 15th century, was not merely an age of feudal loyalty and divine authority. It was a laboratory in which the idea of law itself was reimagined. One of the most profound shifts began in 1215 with the sealing of the Magna Carta in England. At first glance, it was a peace treaty between King John and rebellious barons. It addressed feudal grievances, inheritance rules, and the regulation of royal forests. Yet embedded within its clauses were principles that would echo across centuries: that the king was subject to the law, that taxation required common consent, and that no free man could be imprisoned or stripped of rights without lawful judgment. The document did not create democracy overnight. It did not grant universal rights, but it planted the radical idea that rulers could be constrained by written law. Over time, jurists and political thinkers would reinterpret its clauses as safeguards of liberty. Across the Atlantic centuries later, its language influenced constitutional frameworks and the development of due process. Equally transformative was the development of common law in medieval England, particularly under the reign of Henry II. Rather than relying solely on local customs or arbitrary decisions, royal courts began to standardize legal procedures. Judges traveled on circuits, hearing cases and recording decisions that could guide future rulings. This accumulation of precedent created a body of law that was not written in a single code but evolved case by case. Trial by jury began to replace older practices such as trial by ordeal, where guilt might be determined by surviving boiling water or other dangerous tests believed to reveal divine judgment. By shifting toward evidence and sworn testimony, medieval legal reforms gradually anchored justice in human deliberation rather than supernatural signs. The common law system would eventually spread to vast parts of the world through colonization and cultural influence, shaping legal traditions in countries far removed from its English origins. While England was forging common law, continental Europe was rediscovering and refining Roman legal thought. The revival of Roman law at universities such as Bologna in the 11th and 12th centuries reintroduced systematic legal reasoning, categorization, and the concept of codified statutes. Scholars studied ancient texts and adapted them to contemporary needs. This synthesis of Roman principles with local customs and Christian doctrine produced sophisticated legal systems that influenced civil law traditions across Europe. Medieval canon law, developed by the Church, also contributed significantly. It governed marriage, inheritance, contracts, and moral conduct. And it established procedures for courts that valued documentation and written records. The Church's insistence on written evidence and appeals processes strengthened the habit of formal legal review. In towns and emerging cities, commercial law began to evolve in response to growing trade networks. Merchants needed predictable rules to conduct business across borders. The law merchant, or lex mercatoria, developed as a flexible body of customs recognized in trading centers from the Mediterranean to the North Sea. It emphasized contracts, credit instruments, and dispute resolution through merchant courts. This legal culture encouraged trust between strangers and facilitated the expansion of markets. Without such frameworks, long-distance trade would have been riskier and more limited. The rise of guild regulations in cities also standardized apprenticeship systems, quality control, and labor practices. These rules were restrictive in some ways, but they created shared expectations that stabilized urban economies. Feudal law, often caricatured as a rigid hierarchy of obligations, also introduced enduring concepts. The reciprocal relationship between lord and vassal was defined by mutual duties, protection in exchange for service. Although deeply unequal, this arrangement fostered the notion that authority carried responsibilities. If a lord failed in his obligations, loyalty could be questioned. Such ideas subtly undermined the belief in absolute unchecked power. Over centuries, the tension between feudal privilege and royal authority led to assemblies such as parliaments and estates general, where representatives of different social orders negotiated taxation and policy. These gatherings did not represent modern democracy, but they institutionalized consultation and consent. Medieval legal changes also reshaped the understanding of individual status. The gradual decline of serfdom in many regions was accompanied by legal pathways to freedom. In some areas, a serf who lived in a chartered town for a year and a day could claim liberty. Town charters granted inhabitants certain rights, including self-governance and protection from arbitrary feudal interference. These charters were legal documents that transformed social identity. The concept that a person's status could change through lawful residence or economic participation hinted at a more fluid social order. Marriage law underwent important transformations under canon law. By recognizing mutual consent as the core of a valid marriage, rather than solely parental arrangement or property exchange, the Church elevated the role of personal agreement. Though medieval marriages were still shaped by family strategy, the emphasis on consent laid groundwork for later legal definitions of marriage. Inheritance laws, too, evolved to clarify property transmission, reducing violent disputes and stabilizing family wealth structures. Written wills became more common, reflecting a growing reliance on documentation and testamentary intent. Criminal law also experienced shifts. The move away from ordeals and toward inquisitorial and adversarial procedures changed how guilt was determined. The prohibition of trial by ordeal in the 13th century, influenced in part by ecclesiastical reform, forced secular courts to develop alternative methods of proof. Juries, witness testimony, and written indictments gained prominence. Punishments remained harsh, but the procedural framework became more structured. Over time, these procedural norms contributed to the idea that fairness in process was as important as the outcome itself. Property law in the medieval period became increasingly sophisticated. Concepts such as tenure, leasehold, and entail-shaped land ownership patterns for centuries. The legal distinction between possession and title clarified disputes, and enabled more complex transactions. In urban contexts, municipal statutes regulated building standards, sanitation, and public order. Though often overlooked, these local laws improved living conditions and established precedents for civic governance. The notion that a community could legislate for the common good anticipated modern municipal law. Another quiet transformation occurred in the realm of taxation and fiscal accountability. Medieval rulers needed funds for wars and administration. To secure revenue, they often negotiated with representative bodies. Agreements about taxation created records, audits, and expectations of accountability. Financial administration became more bureaucratic, relying on clerks and written accounts. This administrative evolution strengthened state capacity and professionalized governance. Over time, the machinery of record, keeping and standardized taxation would underpin centralized nation-states. The legal treatment of universities also signaled change. Medieval universities received charters, granting them autonomy, legal privileges, and protection from local interference. Scholars could appeal to ecclesiastical courts rather than secular authorities. This recognition of institutional rights fostered intellectual independence and transnational academic networks. Legal protections allowed scholars to debate, teach, and write with a degree of security. The institutional autonomy granted in the Middle Ages laid foundations for modern academic freedom. Even maritime law developed during this period. Coastal cities codified rules governing shipping, salvage, and maritime contracts. These regulations reduced uncertainty in sea trade and influenced later admiralty law. The recognition that commerce required specialized legal frameworks demonstrated a growing awareness of economic complexity. Law was no longer merely a tool of feudal order. It was becoming an instrument for facilitating growth. The medieval era also witnessed the emergence of written constitutions in certain city-states. Italian communes drafted statutes outlining the powers of magistrates and the rights of citizens. Though oligarchic, these documents represented a commitment to governance by articulated rules rather than personal decree. The practice of codifying civic norms strengthened the expectation that authority must operate within defined limits. Over time, these medieval legal innovations converged. Written charters constrained rulers. Precedent-based systems promoted consistency. Commercial customs encouraged cross-border trust. As the medieval legal order continued to consolidate, its most enduring achievement may have been the normalization of constraint. Power had always existed. Authority had always commanded. But medieval law gradually insisted that power be expressed through recognized channels. Kings issued writs rather than mere spoken commands. Lords relied on documented rights rather than inherited memory alone. Towns defended privileges through sealed charters. Constraint did not eliminate dominance, but it reshaped its expression. Authority increasingly wore the clothing of legality. This normalization of constraint influenced the psychology of governance. Rulers came to understand that legitimacy depended not only on force, but on adherence to accepted norms. Breaking those norms risked rebellion framed in legal terms. Even revolts often cited violated charters or customary rights. The language of resistance was legal, because law had become the shared vocabulary of political life. Medieval legal development also redefined the concept of community. Earlier societies were bound primarily by kinship or loyalty. By the later Middle Ages, communities were also bound by shared statutes. Town dwellers followed municipal ordinances. Guild members adhered to collective regulations. Scholars operated under university statutes. These written rules created collective identity. Membership meant participation in a defined legal order. This transformation strengthened cohesion in growing urban centres. The increased sophistication of inheritance law further stabilized social structures. Clear rules governing succession reduced violent disputes among heirs. Entails preserved estates intact. Dowries structured marital alliances. Guardianship provisions protected minors. Though often reinforcing hierarchy, these legal mechanisms reduced unpredictability. Stability in succession contributed to broader political and economic continuity. Commercial expansion relied on similarly refined structures. Maritime codes, partnership agreements, and credit instruments became enforceable across regions. The law merchant, recognized in trading centers, allowed merchants from different territories to transact with confidence, without such cross-border legal understanding. Long-distance trade would have faltered. Medieval commercial law quietly laid foundations for global exchange. The idea of precedent deepened judicial consistency. Judges increasingly looked to prior decisions when resolving disputes. This habit created continuity and limited arbitrary divergence. It fostered predictability. People could anticipate likely outcomes based on earlier rulings. Predictability encouraged economic planning and social stability. The refinement of evidence-based procedure continued to shape justice. Accusations required formal presentation. Testimony was sworn records preserved outcomes. The abandonment of ordeal in favor of human deliberation signaled confidence in rational evaluation. Though imperfect and influenced by status, this procedural evolution marked a decisive cultural step. The growth of archives had symbolic as well as practical importance. Stored charters and court rolls embodied memory. They represented continuity across generations. Communities invoked ancient documents to defend liberties. The existence of documentary proof strengthened the idea that rights were durable, not temporary favours. Medieval law also fostered gradual centralisation. Royal courts extended jurisdiction into areas once dominated by local custom. Administrative districts were defined. Officials were appointed with specified duties. Centralisation did not erase local autonomy, but layered governance in structured ways. This layering created resilient political systems capable of managing larger territories. Educational institutions reinforced legal continuity by training professionals who shared interpretive frameworks. Jurists carried techniques of reasoning from one region to another, spreading consistency. Their scholarship linked revived Roman principles with local custom, creating hybrid systems that balance tradition and innovation. The articulation of corporate personality, recognizing groups as legal entities, enabled institutions to endure beyond individual members. Monasteries, towns, and guilds could own property, enter contracts, and defend rights. This concept of collective legal identity underpins modern corporations, municipalities and associations. Crucially, medieval law cultivated the belief that governance required justification. Policies were defended by citing precedent or charter. Even monarchs framed authority as rooted in established order. This rhetorical discipline constrained arbitrary action and reinforced legitimacy. The cumulative effect of these developments reshaped global history. When later centuries produced constitutional revolutions, parliamentary systems, and codified legal frameworks, they built upon medieval foundations, the expectation that rulers were bound by law, that contracts were enforceable, that institutions possessed continuity, and that disputes followed procedure had already become embedded in social consciousness. The transformation was gradual and often invisible to contemporaries. No single reform changed the world. Instead, thousands of incremental adjustments, each charter sealed, each case recorded, each office defined, constructed a durable architecture of order. Modern society, with its complex legal codes, judicial systems, corporate structures, and administrative states, rests upon this medieval groundwork. The idea that power must justify itself within recognized norms, that rights can be documented and defended, and that justice depends on procedure rather than whim. These principles are medieval inheritances. Thus, medieval laws quietly changed the world, not through dramatic upheaval, but through patient construction. They replaced instability with structure, arbitrariness with precedent, and memory with documentation. In doing so, they shaped how humanity understands authority, community, and justice. Long after the age itself has passed, its legal architecture continues to support the modern world. As the medieval legal tradition approached the cusp of the early modern world, its most powerful achievement was not a single doctrine or statute, but the creation of a culture in which law became the default framework for resolving uncertainty. In earlier centuries, uncertainty was answered with force, oath, or divine appeal. By the later Middle Ages, uncertainty was increasingly answered with procedure. Disputes were filed, claims were articulated, evidence was examined, judgments were recorded. The normalization of this process fundamentally altered how societies absorbed conflict. Known of the quiet revolutions of the period was the increasing expectation of continuity in obligation. A contract did not expire because memories faded. It endured because it was written and sealed. A right did not vanish with a change in leadership. It persisted because it was archived. This durability shifted social relationships from fragile personal bonds to structured commitments. Trust no longer depended solely on reputation. It rested on enforceable documentation. The growth of royal and urban courts also cultivated territorial unity. As centralized authorities extended jurisdiction over broader regions, local variation began to narrow. Standard procedures replaced purely customary practices. While diversity remained, a shared legal culture emerged within realms. That shared culture strengthened political cohesion and laid groundwork for later nation-states. The refinement of fiscal systems reinforced administrative sophistication. Taxation required assessment, record, keeping, and accountability. Officials who mismanaged funds could face inquiry. Even if enforcement was uneven, the concept of fiscal oversight took root. Governance became increasingly bureaucratic rather than purely feudal. The transition from personal levy to structured revenue collection marked a decisive step toward modern statehood. Medieval law also reshaped economic imagination. With enforceable contracts and predictable dispute resolution, entrepreneurs could take calculated risks. Investment expanded. Markets interconnected. Credit systems developed because legal frameworks protected lenders and borrowers alike. The quiet infrastructure of commercial law supported economic transformation long before the rise of global empires. The emphasis on precedent created stability across generations. Decisions were not isolated, they were linked. Judges cited earlier rulings, building cumulative authority. This continuity prevented abrupt shifts and reinforced confidence in institutions. The idea that law evolves through layered interpretation rather than sudden decree remains central to many modern systems. Communal governance likewise matured. Town councils, guild assemblies, and regional estates debated regulations affecting daily life. While participation was restricted, the experience of collective deliberation fostered civic habits. Communities learned to see law not merely as command from above, but as something shaped through structured discussion. The medieval articulation of rights, though limited by hierarchy, introduced the language of entitlement. Privileges were recorded, exemptions were specified, liberties were enumerated. Even if granted selectively, these documented rights created a vocabulary later reformers would expand. The notion that rights could be written and preserved became deeply embedded. Procedural safeguards continued to evolve. The requirement of formal accusation, opportunity for defense, and recorded judgment strengthened perceptions of fairness. Even harsh punishments carried greater legitimacy when imposed through recognizable stages. The procedural dimension of justice became as significant as the outcome. As the medieval legal order reached its later centuries, something remarkable had occurred. Almost without announcement, law had become the organizing grammar of society. People increasingly described relationships between ruler and subject, merchant and buyer, husband and wife, master and apprentice, not simply in terms of custom or loyalty, but in terms of defined rights and obligations. This legal framing changed how individuals interpreted both opportunity and injustice. A grievance was no longer only a misfortune, it could be a violation. That shift from personal complaint to articulated claim was transformative. The culture of petitioning illustrates this evolution vividly. Subjects across social ranks submitted written appeals to higher authorities seeking redress. Whether complaining about corrupt officials, unfair taxation, or local disputes, petitioners invoked established principles. They framed arguments using the language of precedent and chartered privilege. The act of petitioning reinforced a belief that governance was accountable. Even when relief was denied, the very existence of a channel for appeal strengthened institutional legitimacy. The medieval emphasis on hierarchy did not contradict legal development. Rather, it structured it. Status determined privileges and burdens. But those privileges and burdens were increasingly codified. Nobles asserted ancient liberties. Towns defended municipal rights. Clergy relied on canon protections. The articulation of hierarchy in legal terms made power more predictable. Predictability reduced chaos, even if inequality remained. In economic life, The reliability of law nurtured long-distance trust. A merchant in one city could enter agreements with a partner hundreds of miles away, confident that disputes could be adjudicated. Legal predictability reduced transaction costs and risk. As networks expanded across regions and seas, this confidence became indispensable. The legal frameworks of the Middle Ages quietly supported the expansion of commerce that would later reshape global history. Administrative sophistication also deepened. Officials kept accounts, recorded judgments, and maintained registers of land and taxation. These bureaucratic practices were not dramatic innovations, but they increased state capacity. Governance became systematic rather than episodic. The ability to collect revenue reliably, enforce judgments consistently, and maintain records over decades gave rulers durable authority. Medieval law also fostered a culture of negotiation. Charters were often the result of bargaining between rulers and communities. Privileges were exchanged for loyalty or financial support. This contractual spirit embedded the idea that governance could be shaped through agreement, rather than imposed unilaterally. Later constitutional frameworks would echo this negotiated model of authority. The refinement of legal categories further expanded intellectual discipline. Distinctions between real and personal property, public and private wrongs, contract and tort, like injuries, intention and accident, all sharpened analytical reasoning. Law became a field of systematic thought. Jurists debated definitions and reconciled contradictions. This intellectual rigor contributed to the broader revival of scholarship during the later medieval centuries. Crucially, the authority of law began to transcend individual rulers. Even powerful monarchs felt compelled to justify actions through reference to established norms. To violate law openly risked resistance framed in legal language. Rebellions were justified as defenses of ancient rights. This paradoxical effect, law empowering both authority and opposition, demonstrated its centrality. The growing permanence of institutions strengthened social continuity. Guilds, universities, councils, and courts developed internal rules governing succession and procedure. Leadership could change without dissolving structure. This stability encouraged long-term planning and investment. Institutions gained identities that endured across generations. Even punishment evolved toward greater standardization. Fines, imprisonment, and public penalties followed increasingly consistent patterns. The effort to calibrate punishment to offense, however imperfect, reflected maturing concepts of proportionality. Proportional justice strengthened trust in adjudication. The territorialization of law also advanced. Boundaries were marked, jurisdictions defined, and administrative districts clarified. Governance became geographically structured. This territorial consciousness laid foundations for the nation-state model that would dominate later centuries. As medieval society confronted crises, plague, famine, war, law responded with adaptation. Wage regulations, relief measures, and emergency levies reflected attempts to manage upheaval within structured frameworks. Though some responses were restrictive, they underscored law's role as a tool for navigating instability. The cumulative impact of these developments cannot be overstated. Medieval law reshaped how societies understood authority, economy, and identity. It cultivated habits of documentation, negotiation, precedent, and accountability. It transformed personal loyalty into institutional obligation. It made governance durable and disputes structured. By the dawn of the modern age, the foundations were firmly in place. Written charters limited rulers. Courts operated through recognizable procedure. Commerce relied on enforceable agreements. Institutions persisted beyond individuals' rights, though unevenly distributed, were articulated and defended. The Middle Ages did not create modern democracy or universal equality, but they constructed the scaffolding upon which such ideas could later rise. They redefined power as something exercised within a web of rules rather than through unrestrained command. They normalized the belief that authority required justification and that justice required process. In this gradual, almost imperceptible manner, medieval laws changed the world. They did not do so through a single proclamation or sweeping reform. Instead, they transformed society through accumulation, through thousands of recorded judgments, negotiated charters, procedural refinements, and institutional evolutions. Their legacy endures wherever governance relies on documented authority, where contracts bind strangers, where courts deliberate according to precedent, and where power is measured against principle. As the medieval legal tradition matured further, it began influencing not only how societies were governed, but how individuals imagined justice itself. Justice was no longer viewed purely as the will of the powerful or as divine mystery. It became something that could be studied, debated, interpreted, and even systematized. This intellectualization of law marked a decisive shift. Law transformed from habit into theory, from custom into conscious design. Medieval jurists increasingly wrote commentaries analyzing statutes and prior rulings. They compared local practice with revived Roman principles, reconciled contradictions, and built frameworks of interpretation. Law became a discipline with internal logic. This move towards systematization allowed legal thought to travel across regions. Scholars trained in one territory could serve in another because they shared methodological tools. The standardization of reasoning strengthened coherence across political boundaries. The very idea of codification gained momentum during the later medieval centuries. Rulers sought to compile scattered decrees into organized collections. While not always comprehensive, these compilations made law more accessible and transparent. Codification signaled confidence that governance could be structured and rational. It also reinforced the expectation that law should be written and publicly recognized. The medieval transformation also shaped social contracts in subtle ways. Communities negotiated privileges, and rulers confirmed them in charters. These exchanges created mutual obligations grounded in documented agreement. Though not democratic in a modern sense, this reciprocal model of authority differed sharply from earlier, purely unilateral power. The seed of consensual governance lay within these negotiated relationships. Urban legal life continued to evolve. As cities grew, municipal statutes addressed sanitation, trade standards, fire safety, and public conduct. These regulations reveal a shift toward collective responsibility. Law became a means of organizing complex communities. It regulated shared spaces and mediated competing interests. The capacity to legislate for public welfare, foreshadowed modern civic governance. Medieval legal development also influenced concepts of equality, albeit within constraints. While status distinctions remained powerful, the principle that similar cases should be treated alike gained traction. Precedent encouraged consistency. Arbitrary deviation invited criticism. This movement toward consistency nurtured early notions of fairness, grounded in uniform application of rules. The enforcement of contracts expanded beyond commerce into everyday life. Apprenticeship agreements, marriage settlements, land leases, and partnership arrangements relied on legal backing. The enforceability of these agreements strengthened personal planning and economic confidence. Individuals could commit to long-term relationships knowing that law supported continuity. Another profound development was the growth of legal consciousness among ordinary people. Even those who were illiterate understood the importance of charters, seals, and court proceedings. They recognized that rights could be documented and defended. This awareness cultivated participation in legal processes. People appeared as witnesses, litigants, and petitioners. Law became embedded in social experience. As medieval legal systems grew denser and more interconnected, they began reshaping something fundamental: the relationship between time, authority, and obligation. Law was no longer reactive alone. It became anticipatory. Rules were drafted not just to settle disputes after they occurred, but to prevent instability before it emerged. Regulations governing succession aimed to avert civil war. Trade standards sought to prevent fraud before trust collapsed. Municipal ordinances attempted to stop fires, riots, and shortages before they spiraled. This preventive function marked a quiet but critical expansion of law's purpose. It was no longer merely corrective, it was protective. Another gradual transformation occurred in how legitimacy was narrated. Medieval rulers increasingly justified policies by invoking ancient customs or established rights. Even when introducing new measures, they framed them as restorations of tradition. This rhetorical strategy reveals how powerful legal continuity had become. Innovation required grounding in precedent. Authority felt compelled to speak the language of legality. That need to justify action within a recognized framework constrained arbitrary governance more effectively than brute opposition alone. The medieval court system also normalized the presence of third-party judgment. Disputes were increasingly placed in the hands of officials expected to remain impartial. Though impartiality was imperfect, the ideal itself became culturally embedded. Communities began distinguishing between personal loyalty and institutional duty. A judge was not merely a servant of a lord, but a representative of law. That conceptual distinction would later underpin the independence of judiciary systems. The evolution of record keeping deepened social trust in institutional memory. Court rolls, tax registers, and property deeds preserved commitments across decades. The written record allowed future generations to verify agreements. Without it, rights would depend solely on living witnesses. The permanence of documentation reduced uncertainty and made long-term planning possible. Economic expansion, inheritance security, and political negotiation all depended on this archival stability. Medieval law also subtly expanded the idea of collective welfare. Regulations on grain storage, bridge maintenance, or urban sanitation reflected recognition that communal safety required structured oversight. While rooted in practical necessity, these measures fostered an early sense of public policy. The belief that authorities bore responsibility for common welfare would later evolve into modern concepts of governance. Guild statutes illustrate how law balanced protection and restriction. They safeguarded quality standards and provided mutual aid, yet limited entry and competition. This duality reveals an enduring feature of legal systems. They structure opportunity while defining boundaries. Medieval guilds taught societies how regulation could both stabilize and constrain markets. Another profound shift was the increasing formalization of consent. In marriage law, commercial contracts, and civic oaths, voluntary agreement gained legal significance. Consent was not always freely given, but the principle that valid obligations required acknowledgement strengthened personal agency within structured systems. The importance attached to agreement would later become central to contract theory and political philosophy. Legal pluralism, multiple overlapping jurisdictions, also fostered adaptability. Secular courts, ecclesiastical tribunals, manorial courts, and merchant forums operated simultaneously. While this complexity could cause confusion, it also offered avenues for appeal and reinterpretation. Competing jurisdictions refined procedures to maintain credibility. The resulting dialogue among systems enriched legal development. The professionalization of advocacy marked another turning point. Trained representatives articulated arguments on behalf of clients. Legal reasoning became specialized. This expertise contributed to consistency and coherence. It also democratized access to justice incrementally, as individuals could rely on knowledgeable intermediaries rather than personal influence alone. Medieval taxation law further reinforced the concept of reciprocal obligation. Levies were often tied to protection or representation. Even if representation was limited, the expectation of exchange strengthened the idea that authority required justification. Subjects were not merely resources. They were participants in a structured relationship. In matters of criminal justice, the shift from ordeal to evidence-based inquiry underscored confidence in rational evaluation. The requirement of witness testimony, jury deliberation, or written accusation signaled a cultural movement toward reasoned assessment. Though imperfect, this reliance on human judgment over divine trial reshaped perceptions of truth and responsibility. The articulation of territorial boundaries refined notions of sovereignty. Treaties described frontiers, charters defined jurisdictions. Governance became geographically defined rather than purely personal. This territorial consciousness laid groundwork for the nation state system that would emerge centuries later. The cumulative effect of these developments was transformative precisely because it was gradual. Medieval law did not emerge from a single revolution. It evolved through thousands of small decisions, each clarified obligation, each recorded precedent, each codified custom, added another layer to an expanding structure of order. By the close of the medieval era, societies were accustomed to living within articulated legal frameworks. Authority was exercised through documented procedure. Disputes were resolved through adjudication. Economic exchange depended on enforceable agreements. Institutions possessed continuity beyond individual lives. Even resistance to authority was framed in legal language. Rebels claimed violated rights rather than rejecting law itself. The medieval world thus redefined governance by embedding rules at the core of social organization. It cultivated habits of documentation, precedent, consent, and accountability. These habits became so normalized that later generations inherited them as assumptions rather than innovations. Modern constitutional systems, commercial law, institutional governance, and procedural justice all rest upon this layered medieval foundation. The transformation was quiet because it unfolded across centuries, yet its consequences were vast. Medieval laws changed the world not by spectacle, but by persistence, by steadily teaching societies to anchor power in principle and community in codified order. As the medieval centuries drew closer to the threshold of the modern age, the cumulative force of legal development began reshaping not just governance, but imagination itself. Law was no longer merely a reaction to disorder. It had become a framework within which societies conceived possibility. People increasingly planned their futures, assuming that agreements would hold, that inheritance would follow rules, that offices would continue beyond individuals, and that disputes could be resolved without bloodshed. This quiet psychological transformation, trust in structured continuity, may have been the most enduring medieval legacy. One of the profound changes was the normalization of written authority over oral dominance. In earlier eras, power often flowed from proclamation and memory. By the later Middle Ages, written statutes, sealed charters, and recorded judgments carried decisive weight. A parchment bearing a recognized seal could outweigh even the loudest claim. This reliance on documentation transferred legitimacy from voice to text. It reduced the volatility of political life, anchoring it in preserved agreements rather than shifting declarations. The growth of institutional identity also strengthened continuity. Universities, guilds, towns, monasteries, and councils were recognized as legal entities capable of enduring beyond the lifespan of members. This recognition created stable frameworks for collective action. Institutions could own property, sue and be sued, enter contracts, and negotiate privileges. They became actors within legal systems rather than mere gatherings of individuals. Modern corporations, municipalities, and associations still reflect this medieval innovation. The increasing refinement of financial law further expanded the horizon of economic possibility. As credit instruments, partnerships, and insurance agreements gained legal enforceability, merchants could undertake ventures previously too risky to attempt. Law reduced uncertainty, and reduced uncertainty encouraged ambition. The medieval marketplace, protected by legal predictability, evolved into a dynamic engine of exchange that would later fuel global trade networks. Procedural regularity became deeply ingrained. Courts followed established sequences: summons, accusation, response, evidence, deliberation, judgment. This order was more than ritual. It was a structure that reinforced fairness. Even when outcomes disappointed, adherence to recognizable procedure granted decisions a form of legitimacy. That belief in procedural justice would become a cornerstone of modern legal culture. Another subtle shift involved the conceptualization of responsibility. Medieval law increasingly distinguished between negligence accident, and deliberate harm. This differentiation required inquiry into intent and circumstance. It reflected a growing sensitivity to nuance in human behavior. By recognizing varying degrees of culpability, courts shaped a more sophisticated understanding of moral and legal accountability. As governance matured, rulers also began framing authority as stewardship rather than possession. As the medieval legal order matured further, it began influencing not only institutions and rulers, but the rhythm of daily life itself. Law gradually moved from being something invoked only in moments of crisis to something quietly structuring ordinary existence. Markets opened and closed at regulated times. Contracts were drafted with formulas that became standardized. Disputes over fences, wells, mills, and livestock followed recognizable procedures. Over time, law ceased to feel exceptional, it became ambient. And that normalization of regulated order was itself revolutionary. One of the most significant yet understated transformations was the growing idea of continuity beyond individual reigns. In earlier centuries, the death of a ruler could plunge territories into uncertainty. But as legal administration became more bureaucratic and record-based, governance gained permanence. Seals, archives, and registries ensured that agreements survived political transitions. Offices did not vanish when individuals did. This institutional continuity fostered long-term stability. It meant that promises, debts, rights, and obligations endured regardless of who occupied the throne. That continuity is foundational to the modern state. Medieval law also reshaped concepts of accountability. Officials increasingly had to answer for misconduct. Complaints could be filed against sheriffs, bailiffs, or magistrates. Investigations, though imperfect, acknowledged that authority was subject to scrutiny. This marked a subtle but profound shift from purely hierarchical obedience toward conditional legitimacy. The expectation that power could be reviewed and corrected planted seeds for later doctrines of oversight and checks on authority. In economic life, the recognition of negotiable instruments and transferable obligations enhanced flexibility. Credit could move without the physical transfer of coin. Written acknowledgments of debt were honored in distant courts. Trust became abstracted from face. To face relationships and embedded instead in legal enforceability. This abstraction of trust allowed commerce to scale far beyond local networks. Without dependable legal backing, such scaling would have been impossible. The medieval emphasis on documentation also reshaped memory itself. Written law reduced reliance on oral tradition. Agreements were preserved not just in recollection, but in parchment. Archives accumulated layers of decisions, grants, and statutes. This accumulation created a sense of historical depth. Communities could point to documented rights centuries old. Legal memory became a powerful tool in political negotiation. It allowed present generations to anchor claims in recorded pasts. The regulation of public space further illustrates law's subtle transformation of society. Streets, bridges, and marketplaces were governed by ordinances concerning maintenance, behavior, and trade. These regulations fostered shared standards in increasingly crowded urban environments. As towns grew, the need for structured coexistence intensified. Law provided mechanisms to manage complexity. It organized human interaction at scale. Medieval legal thought also refined the balance between custom and reform. While deeply respectful of tradition, jurists recognized that circumstances changed. They debated how to reconcile inherited norms with new realities. This dynamic tension between continuity and adaptation prevented stagnation. It allowed legal systems to evolve without abandoning legitimacy rooted in the past. The habit of gradual reform became embedded in governance. The differentiation of rights based on status, though hierarchical, nonetheless clarified expectations. Nobles, clergy, merchants, artisans, and peasants operated within defined legal frameworks. While unequal, these frameworks provided predictability. Predictability reduced arbitrary treatment and encouraged planning. Over centuries, debates about expanding or redefining status categories would draw upon this established language of rights and duties. The medieval courtroom also functioned as a theatre of persuasion. Litigants constructed narratives supported by testimony and precedent. Judges weighed arguments within structured guidelines. This environment cultivated rhetorical skill and logical reasoning. It trained societies to value structured debate. Political discourse in later centuries would inherit these habits of argumentation. Furthermore, medieval legal culture strengthened the concept of collective identity. Corporations, whether towns, guilds, monasteries, or universities, were treated as legal persons capable of owning property and entering agreements. This innovation allowed groups to persist across generations. It enabled the pooling of resources and the pursuit of long-term goals. Modern corporations, municipalities, and institutions trace conceptual ancestry to this medieval recognition of collective legal personality. Crisis often accelerated legal evolution. Famine, plague, and war exposed weaknesses in existing systems. Responses frequently took legal form: wage statutes, relief regulations, emergency levies. While some measures were restrictive, they demonstrated that law could adapt to extraordinary circumstances. The capacity to legislate in response to crisis enhanced resilience. The interplay between secular and ecclesiastical jurisdictions also enriched legal complexity. Competing claims over marriage, inheritance, morality, and property forced clearer delineations of authority. Negotiations between these spheres refined jurisdictional principles. The result was not uniformity but layered governance. This layered structure allowed flexibility while maintaining order. As the medieval period approached its end, printing technology amplified the reach of law. Statutes and legal commentaries could circulate more widely. Standardizing interpretation, legal knowledge became less confined to narrow circles. Transparency, though still limited, expanded incrementally. The accessibility of legal texts reinforced the idea that law was something articulated and reviewable. Perhaps the most enduring legacy of medieval law was the internalization of procedural fairness. Even when outcomes were harsh, the process itself gained importance. Being heard, presenting evidence, and receiving judgment through recognized steps mattered. This emphasis on procedure strengthened legitimacy. People might resent decisions, but they increasingly expected them to follow established forms. By the threshold of the modern era, the transformation was profound. Authority operated within a framework of documentation and precedent. Economic exchange relied on enforceable contracts. Institutions possessed continuity independent of individuals. Disputes were channeled through courts rather than feuds. Rights were articulated, recorded, and defended. The Middle Ages did not eliminate injustice or inequality, but they fundamentally altered the architecture of power. They shifted societies toward rule, based order, institutional continuity, and procedural legitimacy. These shifts occurred gradually, almost imperceptibly through countless local adjustments and incremental reforms. In the end, medieval laws changed the world not because they were dramatic, but because they endured. They trained generations to think in terms of rights and obligations, precedent and procedure, documentation and accountability. They constructed frameworks within which future revolutions, constitutions, and reforms could take shape. The modern legal landscape, complex, institutional, and deeply procedural, rests upon foundations laid quietly in medieval courts, charters, and councils. And though centuries have passed, the echoes of those foundational transformations continue to shape how societies understand authority, justice, and order today. As medieval legal culture continued to deepen, it began shaping something even more enduring than institutions or procedures. It shaped expectations of legitimacy. Over centuries, people increasingly judged authority not merely by strength, but by whether it operated within recognized legal frameworks. A ruler who ignored established customs risked rebellion. A judge who violated procedure risked losing credibility. Power still existed, sometimes brutally, but it had to cloak itself in legality, that quiet requirement. That authority must appear lawful was transformative. The medieval habit of grounding decisions in precedent reinforced this transformation. Judges did not simply announce outcomes. They referred to earlier rulings, customary practices, or established privileges. This linking of present action to past authority created continuity. It also limited arbitrariness. When law becomes cumulative rather than impulsive, it fosters stability. Each case builds upon another, constructing a web of reasoning that restrains sudden shifts. Over time, precedent becomes a stabilizing force, making governance predictable. The idea of due process slowly crystallized during this era. Formal accusations, the right to respond, the presentation of witnesses, and recorded judgments became increasingly common. While far from modern standards, these steps introduced procedural fairness into daily governance. Justice was no longer a spontaneous declaration. It followed stages. The sequencing of these stages mattered. That sequencing laid early foundations for modern procedural rights. Medieval law also influenced how communities conceptualized ownership. Land, the primary source of wealth, was regulated through intricate systems of tenure and obligation. But beyond land, movable goods and commercial property gained clearer legal definition. As commerce expanded, courts recognized disputes over ships, cargo, tools, and merchandise. The definition of property widened. Legal protection of movable wealth supported urbanization and market growth. As medieval legal systems matured, they began shaping something deeper than governance or commerce. They shaped how individuals understood their place in society. Law increasingly defined not only what people could or could not do, but who they were within a structured order. Status became articulated through rights and obligations. A tenant owed rent, but possessed tenure protections. A guild member owed dues, but enjoyed trade privileges. A cleric was subject to ecclesiastical courts, yet shielded from certain secular punishments. Identity became intertwined with legally recognized roles, and those roles created predictable relationships within the wider community. This predictability was revolutionary in subtle ways. In earlier eras, survival often depended on personal allegiance and shifting power dynamics. By the later Middle Ages, a growing number of interactions were governed by known procedures. Disputes over land, debt, inheritance, or injury followed established channels. Written pleadings replaced spontaneous accusations. Evidence was weighed according to evolving standards. The very expectation that a grievance could be heard and judged through recognized steps reduced reliance on violence. Law gradually monopolized conflict resolution, strengthening centralized authority while simultaneously reducing cycles of feud. Another transformative development was the increasing abstraction of law from immediate personalities. In earlier centuries, the will of a ruler could be indistinguishable from law itself. But over time, the distinction between the king's personal desire and the realm's legal order sharpened. Even monarchs began to speak of the law of the land as something distinct from their individual preference. This conceptual separation allowed subjects to argue that a king's action violated established norms. The idea that law stood above any one person, even the sovereign, did not eliminate absolutism, but it created intellectual tools with which absolutism could later be challenged. Medieval courts also contributed to the refinement of procedural safeguards. The requirement that accusations be formally presented, that defendants respond, and that judgments be recorded built a culture of accountability. Court records preserved reasoning and outcomes, creating transparency within the limits of the era. The existence of documentation meant that legal decisions could be reviewed, referenced, and compared over generations. This accumulation of precedent shaped expectations of consistency. Inconsistency itself became grounds for criticism. In rural communities, manorial courts regulated agricultural life with surprising complexity. They oversaw field rotation, grazing rights, boundary disputes, and communal obligations. Though embedded within feudal hierarchy, these courts provided structured governance at the local level. Peasants could raise complaints, and proceedings were often recorded. Such participation fostered a rudimentary sense of communal legal engagement. Law became woven into seasonal rhythms, tying justice to everyday labor. The expansion of maritime commerce intensified the need for clarity in jurisdiction. Ships traveled across regions governed by different rulers. Determining which court held authority over a dispute required legal reasoning about territory and allegiance. These challenges stimulated the articulation of jurisdictional principles. The notion that authority was geographically bounded, yet capable of interacting with other jurisdictions, became more refined. This evolution was foundational to later international law. Economic growth also spurred innovation in partnership agreements. Merchants pooled capital for voyages and ventures, formalizing arrangements through contracts specifying profit distribution and liability. Courts recognized and enforced these agreements, thereby legitimizing shared risk. Such legal support for collective enterprise contributed to the rise of powerful trading networks and banking houses. Without enforceable partnership law, economic expansion would have been far more constrained. Religious reforms during the later Middle Ages further influenced legal thought. Movements calling for ecclesiastical accountability demanded that church authorities adhere to established canon law. Appeals to councils and higher authorities reflected a belief that institutions were bound by articulated standards. Even spiritual authority was expected to operate within procedural norms. This expectation of accountability within sacred institutions reinforced broader cultural commitments to rule, bound governance. Legal education also deepened professional identity. Students trained in jurisprudence mastered techniques of interpretation, argumentation, and reconciliation of conflicting authorities. They learned to analyze statutes in light of precedent and principle. This intellectual discipline cultivated a shared legal culture that transcended regional boundaries. Jurists across Europe could debate common questions using comparable frameworks. Such shared discourse strengthened the coherence of legal development. Over time, the distinction between public and private spheres sharpened. While earlier societies blurred boundaries between personal obligation and communal authority, medieval law increasingly categorized matters as public offenses or private disputes. This classification structured remedies and punishments. It clarified when the state intervened and when compensation sufficed. The differentiation created clearer limits to authority and more precise expectations of behavior. Legal pluralism remained characteristic of the medieval world. Customary law, royal statutes, ecclesiastical decrees, and urban regulations coexisted. At times this plurality generated confusion, yet it also fostered adaptability. Individuals could navigate among jurisdictions, appealing to different authorities depending on circumstance. The competition among legal forums encouraged procedural refinement. Courts sought legitimacy by demonstrating fairness and reliability. The growth of record preservation had cultural implications beyond administration. Archives became symbols of continuity. They embodied collective memory. When charters were invoked to defend rights, communities were reminded that their liberties were rooted in documented history. The preservation of texts strengthened historical consciousness. Law connected past agreements to present claims, linking generations through written commitment. Even punishment evolved in ways that shaped social order. Public executions and fines were not merely retribution. They reinforced communal norms. Sentences were often calibrated to the severity of the offence and the status of the offender, reflecting an increasingly nuanced approach. Though harsh by modern standards, medieval penal practices operated within frameworks that emphasized proportion and procedure. Perhaps most importantly, medieval law normalized the idea that disputes were legitimate subjects of reasoned debate. Courts were arenas of argument. Lawyers and litigants presented evidence, cited precedent, and constructed narratives. This culture of argumentation cultivated habits of rational discourse. It taught societies that conflicts could be addressed through structured reasoning rather than brute assertion. By the dawn of the modern era, these accumulated habits had transformed Europe's political and economic landscape, states possessed administrative capacity grounded in documentation. Commerce relied on enforceable contracts. Institutions operated under charters, defining their authority. Individuals framed grievances as violations of rights rather than mere misfortunes. The intellectual groundwork for constitutionalism, market economies, and bureaucratic governance had been laid. The medieval world did not experience a single legal revolution. Instead, it underwent centuries of incremental recalibration. Each reform, each clarification, each procedural adjustment nudged society toward a more institutionalized conception of order. Law became both the language of power and the instrument for restraining it. Today, when courts deliberate on constitutional principles or corporations draft international contracts, they operate within traditions shaped long ago: the expectation of written documentation, the reliance on precedent, the recognition of institutional continuity, and the belief in procedural justice all echo medieval developments. The transformation was quiet because it unfolded gradually, woven into everyday practice, rather than announced in sweeping declarations. Yet its impact was immense. Medieval laws did not merely regulate life in their own time. They constructed the framework within which modernity would emerge. They altered how communities defined authority, how markets organized trust, how institutions sustained continuity, and how individuals articulated claims. Through centuries of negotiation, adaptation, and documentation, the Middle Ages quietly reshaped the foundations of the world we inhabit. As medieval legal systems continued to mature, they began influencing not only governance and commerce, but also the psychological relationship between individuals and authority. Law increasingly became something people expected to exist as a stable backdrop to life. Instead of perceiving power as unpredictable and personal, communities slowly internalized the belief that authority functioned through known procedures. That mental shift, subtle, gradual, almost invisible, may have been the most transformative of all. One of the clearest signs of this shift was the normalization of legal consultation before action. Rulers did not always act impulsively. They often sought counsel from jurists trained in interpreting statutes and precedent. As the medieval centuries progressed, law began to shape not only governments and markets, but also the moral imagination of entire societies. One of the most understated yet transformative changes was the idea that justice should be public. Early medieval settlements were often private affairs, resolved within kin groups or through negotiated compensation. But over time, disputes increasingly unfolded in open courts in front of officials and communities. Justice became something witnessed. This public character of law reinforced accountability. It sent a message that wrongdoing was not merely a personal insult, but a disturbance of communal order. The shift from private feud to public prosecution altered social expectations, embedding the belief that the maintenance of order belonged to institutions rather than families alone. The growth of royal justice further expanded this principle. When monarchs asserted the right to hear cases that once fell under local lords, they centralized authority and reduced fragmentation. This expansion was gradual, often resisted, yet persistent. By positioning the crown as the ultimate source of justice, rulers strengthened territorial cohesion. At the same time, They bound themselves to the standards of the courts they sponsored. If royal justice was perceived as arbitrary, it undermined legitimacy. Thus, even powerful monarchs had incentive to cultivate fairness, or at least the appearance of it. The expectation that rulers should dispense justice impartially was itself a revolutionary development compared to earlier eras of personal rule. Urban autonomy deepened these transformations. As towns secured charters granting self-governance, they developed municipal councils and codified local statutes. Citizens elected or appointed officials, responsible for adjudicating disputes, regulating trade, and maintaining infrastructure. This experience of participatory governance, however limited to certain classes, nurtured habits of civic responsibility. Urban dwellers learned to negotiate rules collectively. The city became not merely a marketplace, but a legal community with articulated rights and obligations. These practices foreshadowed later republican traditions. Medieval legal systems also began to articulate clearer boundaries between civil and criminal matters. While earlier societies often blurred distinctions, medieval courts gradually differentiated between private wrongs requiring compensation and offences against public order demanding punishment. This conceptual separation refined legal reasoning. It allowed for more precise categorization of harm and tailored remedies. Over centuries, these distinctions would expand into the complex branches of modern jurisprudence. Another subtle yet powerful development was the articulation of minority protections within certain contexts. Jewish communities, for example, were sometimes granted royal charters guaranteeing protection and specific rights in exchange for taxes or services. While these arrangements existed within a broader context of discrimination and persecution, the very act of codifying protections reflected a recognition that minority status required legal definition. The tension between protection and exclusion revealed law's dual capacity. It could shield and marginalize simultaneously. This complexity would persist in later centuries, shaping debates about tolerance and citizenship. The medieval regulation of inheritance also reshaped family dynamics. Primogeniture, the practice of granting estates to the eldest son, preserved large landholdings and stabilized noble lineages. In contrast, partible inheritance divided property among heirs, promoting different social outcomes. These legal frameworks influenced economic patterns, migration, and social mobility. Law thus functioned as an architect of demographic and economic realities, determining how wealth flowed across generations. Financial innovations depended heavily on legal trust, bills of exchange, early forms of credit, and partnerships required enforceable agreements. Merchant courts adjudicated disputes swiftly, often prioritizing commercial custom over rigid formalism. This pragmatic approach demonstrated law's adaptability. It showed that legal systems could evolve in response to economic necessity. As trade networks stretched from the Baltic to the Mediterranean, the predictability of commercial law became the backbone of prosperity. Even warfare was increasingly shaped by legal norms. Concepts of ransom, safe conduct, and the treatment of prisoners reflected emerging standards. Chivalric codes, though romanticized, carried legal implications regarding conduct in conflict. Treaties formalized truces and territorial settlements. While war remained brutal, the recognition that even conflict operated within rules marked an evolution in international behavior. Over time, these customs contributed to the foundations of the laws of war. Religious courts, particularly those administering canon law, influenced secular systems by emphasizing written procedure, appeals, and standardized evidence. Marriage cases, testamentary disputes, and moral offences were processed through structured hearings. The insistence on consent in marriage law, though not always respected in practice, introduced a powerful legal principle. Personal agreement held decisive weight. This focus on consent would echo centuries later in contract theory and human rights discourse. The medieval habit of oath-taking also evolved in meaning. Oaths were once primarily sacred pledges invoking divine witness. Over time, they became integrated into judicial procedure as instruments of credibility and testimony. Sworn statements before courts reinforced the seriousness of truth. Telling within institutional settings, the blending of spiritual and legal accountability strengthened the moral authority of courts. As literacy slowly expanded, petitions became a means by which ordinary individuals sought redress. Peasants, merchants, and townspeople submitted written complaints to higher authorities. The act of petitioning acknowledged that rulers bore responsibility to hear grievances. It framed subjects not merely as obedient dependents, but as participants capable of invoking legal principles. Though outcomes varied, the very availability of petitioning fostered a culture in which authority could be approached and questioned. By the close of the medieval era, legal consciousness had deepened. People increasingly understood themselves as holders of defined statuses: tenant, citizen, guild member, scholar, cleric, each accompanied by specific rights and duties. Identity became intertwined with legal classification. This framework structured social interaction and reduced ambiguity. While hierarchy remained strong, the articulation of status created clarity that facilitated negotiation and reform. The cumulative effect of these developments was transformative. Medieval law did not abolish inequality or eradicate injustice. It operated within a world of profound disparities. Yet it provided mechanisms for articulation, negotiation, and accountability. It nurtured procedural thinking and respect for precedent. It elevated documentation and institutional continuity. It introduced the expectation that governance required justification grounded in articulated norms. When early modern thinkers later spoke of constitutionalism, separation of powers, or rule of law, they built upon centuries of medieval practice. The Enlightenment did not invent the idea that authority should be constrained. It inherited and expanded it. The legal revolutions of the 18th and 19th centuries would have been unimaginable without the medieval groundwork of charters, courts, corporate bodies, and codified statutes. Thus, the medieval period's quiet legal transformations reshaped not only institutions, but also the psychological architecture of society. People learned to frame disputes in legal language, to preserve rights in written form, to demand accountability through recognized channels, the rule of law. So central to modern governance, was not born in a single proclamation. It was cultivated across centuries of adaptation and negotiation. In the end, medieval laws changed the world by normalizing the expectation that power answers to principle. They transformed governance from a purely personal dominion into an institutional order. They embedded the belief that justice requires procedure, that contracts require enforcement, that communities require codified norms, and that authority must operate within boundaries. These changes unfolded quietly, often unnoticed by those living through them. Yet their legacy is unmistakable. The structures of our modern legal systems, courts, parliaments, corporate entities, documented rights, carry the imprint of those medieval centuries. And beneath the surface of contemporary life, the echoes of those long-ago statutes continue to shape how we think about law, authority, and freedom. As medieval legal culture matured, it began to cultivate something even more enduring than institutions: expectations. Law trained societies to expect continuity rather than chaos, process rather than impulse, justification rather than mere command. Over generations, these expectations hardened into norms so deeply embedded that they became invisible. Yet they were learned slowly, case by case, dispute by dispute, charter by charter. One of the most transformative developments was the increasing separation between the ruler's personal household and the machinery of governance. In early medieval courts, administration was intertwined with the king's private domain. Officials were companions, lands were granted as favours, and authority radiated outward from personality. Gradually, however, offices became more defined. Sheriffs, bailiffs, chancellors, and treasurers carried specific responsibilities. The transformation did not end with charters and courts. It deepened in ways that subtly reshaped how societies imagined authority itself. In the early medieval centuries, law was often personal. A crime against one man might be settled through compensation to his kin. Justice was negotiated within networks of loyalty, but gradually, law became territorial and institutional. Instead of being bound primarily to a person or clan, legal authority attached itself to a realm, a crown, a city. This shift from personal to territorial sovereignty was not dramatic, yet it changed everything. It meant that the law could outlive a ruler, that it could apply uniformly across lands, and that governance could be conceived as something continuous rather than episodic written record. Keeping played a crucial role in this transformation. The increasing reliance on charters, court rolls, tax registers, and land surveys made law visible and durable. A grant of land was no longer a spoken promise. It was a sealed document stored in an archive. A court judgment was not merely remembered. It was recorded. This habit of documentation created institutional memory. Disputes could be settled by reference to prior rulings. Obligations could be verified through preserved texts. In a world where literacy was limited, the authority of the written word carried immense weight. It anchored rights in something tangible and retrievable. Over centuries, archives became repositories of power, and bureaucratic literacy became a pathway to influence. The development of parliamentary assemblies further altered political expectations. In England, the summoning of representatives from shires and boroughs to consult on taxation evolved into a more structured institution. In France, the estates, general gathered clergy, nobility, and commoners for deliberation. In Spain, the Cortes served as a consultative body. These assemblies did not represent universal suffrage, yet they embodied a principle. Rulers sought consent. especially when imposing burdens. The ritual of consultation normalized the idea that governance involved negotiation. Even when monarchs ignored assemblies, the expectation lingered that authority required justification. The medieval struggle between secular rulers and the church also had profound legal consequences. Disputes over investiture, jurisdiction, and clerical immunity forced both sides to articulate arguments about sovereignty and rights. The very act of debating whether a king or pope held ultimate authority stimulated legal reasoning about the nature of power. Canon lawyers and royal jurists refined concepts of jurisdiction, due process, and appellate review. Appeals could be made to higher courts. Decisions could be challenged. This layered structure of authority fostered a culture in which law was not simply obeyed but interpreted. Guild statutes in urban centres introduced collective regulation into daily life. Artisans agreed on standards of quality, prices, and apprenticeship terms. While these rules protected members, they also reflected an emerging sense of corporate identity. A guild could act as a legal person, owning property and entering contracts. This notion of corporate personality extended to towns, universities, and monasteries. The legal recognition of corporate entities allowed institutions to endure beyond individual lifespans. Modern corporations, municipalities, and associations trace conceptual ancestry to these medieval precedents. Intellectual life was equally transformed by legal frameworks. Universities operated under charters that defined privileges and responsibilities. Scholars were granted certain immunities, enabling them to move across borders. The protection of academic communities encouraged the systematic study of theology, philosophy, and law. Legal scholarship itself became a profession. Trained jurists advised rulers, drafted statutes, and adjudicated disputes. The professionalization of legal expertise ensured continuity and technical refinement. Law was no longer merely custom. It was a discipline requiring study and interpretation. Maritime commerce expanded rapidly during the later Middle Ages, and with it came codified maritime laws. Ports established regulations for cargo disputes, salvage rights, and maritime insurance. These norms fostered trust among traders who risked fortunes on uncertain voyages. By reducing unpredictability, maritime law stimulated economic expansion. It demonstrated that legal innovation could unlock commercial potential. Where predictable rules existed, markets flourished. Crucially, the medieval world also began grappling with the concept of natural rights. Though articulated in theological language, thinkers debated the inherent dignity of individuals. The idea that certain rights derived from divine or natural law, rather than solely from royal grant, introduced a moral dimension to legal claims. Even if these rights were not universally applied, the conceptual groundwork was laid. Later generations would secularize and expand these ideas, but their medieval articulation provided intellectual scaffolding. The decline of ordeals and the rise of evidentiary procedures reshaped criminal justice. Accusations required witnesses or juries. Written indictments formalized charges. Even harsh punishments operated within procedural boundaries. The expectation that guilt must be demonstrated rather than divined strengthened confidence in adjudication over time. This procedural fairness became central to legitimacy. A verdict achieved through recognized steps carried authority that arbitrary punishment could not. Land tenure reforms and inheritance statutes gradually stabilized property relations. Clearer rules reduced violent disputes among heirs. Feudal incidents were regulated, limiting arbitrary exactions. Property became more secure, encouraging investment and agricultural improvement. Economic stability, in turn, reinforced political stability. Law thus became intertwined with prosperity. In some regions, peasant revolts and urban uprisings pressured authorities to codify rights more explicitly. Though many revolts were suppressed, their demands left traces. Rulers recognized that governance required balancing coercion with concession. Concessions often took the form of written privileges or clarified obligations. Each document added another layer to the evolving legal landscape. By the 15th century, Europe's legal environment was complex and multifaceted. Customary law coexisted with codified statutes. Ecclesiastical courts operated alongside secular tribunals. Local regulations intersected with royal decrees. This pluralism could be confusing, yet it also provided flexibility. Individuals might appeal from one jurisdiction to another. Legal arguments became sophisticated, drawing on precedent, theology, and reason. When the early modern period dawned, reformers and revolutionaries inherited this intricate framework. They did not build from nothing. They modified what already existed. The English Bill of Rights, constitutional monarchies, and civil law codes all rested on medieval foundations. The habits of documentation, consultation, corporate identity, due process, and contractual obligation had been normalized centuries earlier. Thus, the medieval era quietly engineered a transition from a world governed primarily by personal loyalty and divine sanction to one structured by institutions and articulated norms. It cultivated the expectation that rulers could be questioned, that laws could be written and preserved, that communities could govern themselves within charters, and that justice required procedure. These shifts were gradual, often contested, and sometimes reversed. Yet cumulatively, they redefined governance. In the end, medieval laws changed not only institutions but mentalities. They taught societies to think in legal categories, to frame grievances as rights, to seek remedies through courts rather than vengeance. They embedded the principle that power operates within a framework of rules. Without that quiet transformation, the later revolutions in political thought and constitutional design would have lacked soil in which to grow. The Middle Ages, often dismissed as static, were in fact a crucible of legal imagination. And from that crucible emerged many of the assumptions that structure our modern world. Beyond courts, charters, and assemblies, the medieval transformation of law also reshaped how societies understood time, obligation, and responsibility. In earlier centuries, justice often revolved around immediate restitution, compensation paid swiftly to restore balance. But as medieval legal culture matured, it became increasingly future-oriented. Contracts specified delivery dates, repayment schedules, and long-term obligations. Wills planned for property distribution years ahead. Leases bound tenants and landlords across seasons. Law began to regulate not just present disputes, but anticipated futures. This subtle shift cultivated a mindset in which stability and predictability were prized. It encouraged investment, planning, and trust in institutions that would endure. One of the most consequential yet understated developments was the growth of legal uniformity within kingdoms. In fragmented early medieval landscapes, customs varied from village to village. Over time, rulers sought to standardize weights and measures, coinage, and commercial regulations. These reforms were not glamorous, yet they strengthened internal cohesion. A merchant could travel farther with confidence that contracts and currencies would be recognized. The harmonization of law within territories fostered economic integration, which in turn reinforced political unity. The idea of a coherent realm governed by consistent norms took root. Legal language itself evolved into a specialized vocabulary.